You got a referral notice after your asylum interview with USCIS. I know that feels like a punch to the gut, but I need to tell you something important. A referral is not an asylum denial. I mean, look, I won't sugarcoat it. It's not good. USCIS decided that you're not eligible for asylum, but to be sure, it's not the end of your road. Your case is still alive, and I'm going to explain exactly what that notice means, what's fundamentally different about the stage that you're entering right now, and what you need to do right now to protect your case, because the window to act is open and you don't want to miss it. I'm also going to tell you about a tactic that ICE is aggressively using, including at the first hearing in immigration court, to secure a deportation order against you before you can even explain your case. And we're starting right now. I'm Brian Manning, and I used to be an asylum officer with the government. I spent 11 years working for the government's two main agencies for asylum and refugee matters, and I adjudicated thousands of immigration applications during that time. But now, well, as an asylum lawyer, my law firm helps immigrants all over the country to secure their future in America through asylum. Let me know in the comments if you've received a referral notice from USCIS, and tell me where you are in the process, whether you're awaiting your first court hearing or your second hearing. Okay, so what exactly is an asylum referral? Well, you went through the affirmative asylum process, right? You filled out your application with USCIS. You may have waited months, maybe even years, for your interview date to finally arrive. And then you sat down with an asylum officer and you answered their questions. You attempted to explain your case, and then, well, you hoped for the best. But then instead of a grant of asylum, you received a referral notice. Now, along with that referral notice came something called a notice to appear. And those two documents arrive together in the same mailing, and together, well, they inform you that your case has been referred to immigration court. What does that mean? Well, it means the government has placed you in formal deportation proceedings. And I want to be direct with you. That moment is hard. It's genuinely disappointing. After everything you went through, right? The waiting, the anxiety, and the interview itself, that is not the outcome that you were hoping for. And if you had an asylum attorney for the affirmative stage who you feel let you down, or maybe you went through the process alone and, now you wish that you had approached some things differently, well, those feelings are completely understandable. And there are a lot of people in that situation. But here's what you need to understand right now. A referral is not a final asylum denial. This distinction matters enormously. You see, the asylum officer did not have the authority to deny your case outright. What they concluded is that they couldn't approve your case at that stage. So the case moves to a completely different decision maker. It's an immigration judge. And that judge, well, they have the full authority to grant your asylum. Now, think of it like this. This is a fresh adjudication, okay? A brand new look at your case before a decision maker who is not bound by what the asylum officer concluded previously. The asylum officer's reluctance to approve your case doesn't follow you into that courtroom like some kind of verdict already stamped on your file. Once you're referred, your case becomes what's called defensive asylum, a fundamentally different process from the affirmative application that you've already been through. And there is something worth knowing here. Immigration courts had higher asylum approval rates than asylum offices in recent years. So yeah, real people who sat through the affirmative asylum interview with USCIS and left without a grant, they went on to win in front of an immigration judge. And my law firm has helped many of those clients reach exactly that outcome. So there definitely is still hope for your case. By the way, if you want to maximize your chances for asylum success, then please be sure to hit the subscribe button and the bell notification so that you don't miss the insights that I share on this channel. Okay, now let's talk about what actually changes when your case moves over to immigration court, because this is where a lot of people get into serious trouble by not understanding what they're walking into. So you see, the affirmative asylum process, which you concluded with USCIS, is what's called a non-adversarial process. There is no opposing attorney trying to tear apart your testimony. In your interview at the USCIS asylum office, well, the officer's job was to evaluate your claim. Yeah, they might push back a little, they might ask some difficult questions, but they're not there to argue against you. But immigration court, well, It's very different. You see, in that courtroom, there is an immigration judge weighing your case, and there's also a government attorney on the other side. And the government attorney, well, this is a prosecutor who works for ICE, and their entire job is to argue against you. Make no mistake, this person is trying to get you deported. They will cross-examine you. They will challenge your evidence. They will look for inconsistencies and press on them hard. See, you're not just being evaluated, you're being actively opposed by a trained attorney whose goal is to get you removed from the United States. They want to make you look bad in front of the judge. They want to make you look like a liar. And I assure you, it's going to be way more intense, way more difficult than what you faced back at the asylum office. And walking into a deportation hearing without an experienced asylum attorney presents serious risks. That's always been true, but it's really more important right now than ever before, given the sneaky tactic that ICE attorneys are using at immigration court hearings. So, under the Trump administration, ICE prosecutors are frequently filing what's called a motion to pretermit. That's a weird name, I know, but in plain terms, the government attorney asks the immigration judge to issue a deportation order against you without even fully hearing your case. You see, ICE typically argues either that your original asylum application was not adequately filled out, or that you could supposedly seek asylum in a third country, some other country. So you should be sent there to make your claim rather than getting to pursue asylum here in the United States. Now, these motions are serious, okay? And critically, they're sometimes raised at the master calendar hearing. That's the very first court appearance that you'll have in immigration court. And this pivotal consequential action by ICE, well, it catches people by surprise. You may have heard that the master calendar hearing is, well, no big deal, just a brief administrative appearance, nothing serious. I mean, the real substantive stuff, you explaining your case, well, that happens at the next hearing, which is called the merits hearing or the individual hearing. But under Trump 2.0, that assumption is genuinely dangerous. You see, if you walk into your master calendar hearing without an asylum attorney and the government files a motion to pretermit, you're at serious risk of a deportation order coming down that very day. That's right, sometimes the judge makes a decision right then and there in ICE's favor, meaning, well, you're ordered deported, just blindsided. So you really, really want to have an attorney present who can identify that motion and fight back against it. You need a lawyer to explain to the judge exactly why ICE's motion has no merit and should thus be denied, such that you should get the chance to fully present your asylum case. Now, my law firm has had success overcoming motions to pretermit, but you cannot fight what you're not prepared for, okay? And actually, my firm is usually able to get that first hearing, the master calendar hearing in immigration court, canceled entirely, skipping straight to the merits hearing. And we do this by submitting something called written pleadings, where we basically do on paper what we would end up doing in person on the day of the master calendar hearing. And this is ideal. It's best to avoid the master calendar hearing altogether. All right, so let me bring this all together. You received a referral notice. Your case is not over. You have a real path forward through defensive asylum, but that path runs through an adversarial proceeding with a government attorney who's working to remove you, and an immigration judge is weighing both sides, and a specific motion that can end your case at the very first hearing could be used against you, especially if you show up without representation. And look, if you did get past your master calendar hearing without a deportation order and you're now waiting for your merits hearing, well, don't squander the gift of time that you've been given. You see, you have time right now to build your defense, time to prepare a solid asylum case. Do not wait until the last minute to do that, okay? Your asylum attorney needs time to help you gather evidence, prepare your declaration, document country conditions, and write an outstanding legal brief. Every week that you wait is a week taken away from your preparation. So use the time you have right now. Look, if you received an asylum referral notice and you want to better understand your options and how you can maximize your chances for success at this critical stage, please call my office today. That number is 713-909-0401. And remember, we help people all over the country, so it doesn't matter where you live. Call us right now to schedule an asylum strategy session so that we can help you to secure your future in America through asylum. Again, I'm Brian Manning, and it's truly an honor to support you in your asylum journey.